Honor, the matter before you is a notice of motion dated 8th of July 2025, supported by an affidavit of Chief Inspector Desterio.
It is dated
Today, 8th of July 2025. Supported, Your Honor, by an affidavit by Chief Inspector Desterio. The affidavit is deponed on an even date, 8th of July 2025. The essence of the application is to request a limitation of the rights to liberty for a period of over 24 hours, and specifically they are requesting for 14 days.
Is it 14?
14 days at Muthaiga Police Station to allow investigations, Your Honor, into matters of collection and provision of property for commission of terrorist acts, Your Honor, and secondly, for investigations of a charge of conspiracy to commit a terrorist act contrary to Section 23 of POTA. Your Honor, the grounds upon which this request is made is that the first respondent, who is a current member of Parliament for Manyatta constituency in Embu County,
Just a minute. You may proceed.
the first respondent is a current.
There's a small oversight on our part before we commence. Your Honor, this application that my learned colleague is trying to prosecute is an application that we saw 10 minutes ago. And obviously, we have not been able to respond to this application. But given the nature of criminal proceedings, the defense will be satisfied with cross-examining Chief Inspector Desterio Omukaga on the content of this affidavit, and we propose it should be only after that cross-examination has taken place that the prosecution should then present its application.
Indeed.
You want to do cross-examination?
Yes, we want to do cross-examination.
Yes, indeed, and for that purpose, Councillor Ireri will lead in that cross-examination. We are obviously vehemently in the position of this motion. So we will have Councillor Ireri lead us in this, and as Councillor Kibe said, only then can the prosecution prosecute the application.
You know, that is
Just a minute. Proceed, Mr. Michel.
Yes, Your Honor, I'm also opposed to that application to cross-examine Chief Inspector, Your Honor, the Chief Inspector who is the IO in this matter. And the reason is on legal basis. The law provides, Your Honor, that whenever any party desires to cross-examine anybody who has sworn an affidavit, then they need to do an application in writing. The said application in writing should highlight the reasons as to why that application may be allowed by the court. You know, we have a myriad of authorities to the effect that cross-examination of a deponent is not a matter of right to any party. But cross-examination, Your Honor, of deponent is an application that should be done formally, supported with the grounds, Your Honor, and these grounds have been specified, Your Honor, by various authorities before a court binding to this court, including the High Court. And as, Your Honor, we respond to that application, which you are saying is not a right, and equally the defense counsel cannot say how they are going to have him cross-examined before the court makes a ruling on the same issue. So this is my objection. One, there is no written application, there is no notice issued for cross-examination, Your Honor, to the Chief Inspector who has deponed the affidavit. Secondly, there is no any written application to request for cross-examination. And thirdly, there is no hearing set for the application to argue as to the propriety of that application and whether the circumstances are right for them to be allowed to cross-examine. Your Honor, I wish to submit authorities.
You said there is no right to cross-examine.
There's no right to cross-examination.
There is no written application and
Your Honor, and there are no grounds that have been set in that application after hearing date has been set to raise or to give the reasons why the IO should be cross-examined. Your Honor, this is a matter that has been decided in the High Court at Mombasa in a constitutional petition number 8 of 2024 in matter of David Abe versus Inspector General of National Police Service, Ministry of Interior and National Coordination.
repeat the citation. Constitutional petition
Number 8 of 2024. David Abe, and Abe is A-B-B-E-Y, versus IG of Police as the first respondent, Ministry of Interior as the second respondent, and the Director of Public Prosecution as the third respondent, Your Honor. Your Honor, the ruling of the court was that the grounds that are supposed to be given for the cross-examination had not been given, and therefore the court declined to allow such an application, Your Honor, and I also served the court with a copy of the same order declining this kind of an application, Your Honor. Your Honor, in another matter, in the Land and Environment Court, Civil Suit number 157 of 2015,
ELC.
ELC
number
157 of 2015, in the matter of Papinda Kaur P-A-P-I-N-D-E-R,
Just repeat.
P-A-P-I-N-D-E-R. Kaur is K-A-U-R at Y, A-T-W-A-L, Atwal,
80.
A-T-W-A-L.
Yes.
Versus Habans, H-A-R-B-A-N-S, Amrit, A-M-R-I-T, and Kamar Parkash, K-A-M-A-L-P-A-K-A-S-H. Yona, a similar application now based on the civil procedure rules, order number 19.
Just a minute. Will they kindly put on the lights inside?
You know, you are told that
It's
the lights
been
are
like this.
defective.
They're not defective.
Ah.
So, you know, in this matter, based on Order 19, Rule 2.1 of the Civil Procedure, which I practiced a few years before joining the Criminal Procedure Code team, Yona stated that that application must be made in writing, and the decision was made that the grounds were not sufficient. You cannot just make that application without laying the basis. And Your Honor, the court declined to give the said application in the said ruling. That is Justice Mutungi, sitting at Milimani Law Courts. Your Honor, the said authority is equally supplied to the defense and a copy supplied to the court. Your Honor, in an anti-corruption matter, similarly, in the matter of Dr. Evans Kidero, who was the first petitioner, and 10 other petitioners, no 11, Your Honor, versus the Chief Magistrate of Milimani Law Courts, Ethic and Anti-Corruption Commission, DPP, and the DCI named respondents,
You said versus?
versus the Chief Magistrate of Milimani Law Courts, Ethics and Anti-Corruption Commission, DPP, and the DCI. The counsel in this matter intended Your Honor to cross-examine an I. And at paragraph 37 of the said judgment, ruling, Your Honor, all the way to paragraph 60, the court gave an analysis as to why the cross-examination of a deponent is not a right and can only be given in limited situations, Your Honor, that are discussed therein. Your Honor, I wish to serve the said authority to the defense and the court for that purpose. Your Honor, and a myriad of other authorities, Your Honor, that I have here. So what you are saying is that that order has been a trend that is just taken lightly. Anyone who wants to cross-examine an IO would just come, and maybe we get sometimes reckless and fail to consult the law. But the law is as is. That prayer cannot be granted orally. If they intend, Your Honor, to have another date set for cross-examination, we need to be served with an application with a legal basis so that we may respond, Your Honor. I have other sets of 5 authorities, Your Honor, that I'll supply should they file that application to cross-examine the defendant. Thank you.
Your Honor, before I give the floor to counsel, it is important for Your Honor to note that none of those authorities have anything to do with the person charged under the Prevention of Terrorism Act. And also further note, Your Honor, that it's like an ambush we are dealing with a member of parliament. If you allow me to make this general statement, member for Manyatta, the country is at a crossroads. The people of Manyatta and the Embu, not just to say the whole country, are watching clearly this political persecution. So it cannot be any other thing. We cannot call it by any other name other than this administration has chosen to carry out political persecution of its opponents. And so we want to urge Your Honor to be able to dispense with that written requirement in view of the urgency and the gravity of the matter before you this evening. I will ask Council Ndegwa Njiru to add to what I've just said.
Your Honor, just a minute. This Ndegwa Njiru. May you proceed?
It's my humble belief, Your Honor, that we are faced with a criminal trial and not a civil one. And that where we are faced with a civil trial, the law applicable therefore is Cap 75. Of great relevance is the title to that act, which provides it's an act of parliament to make provisions for the procedure to be followed in criminal cases.
Yes.
Additionally, Section 3, which provides that all offences under the Penal Code shall be inquired into, tried, and otherwise dealt with in accordance to the code. Therefore, the authorities that have been cited to you can be distinguished that they were brought or the decisions were made under Order 19, Rule 2 in a civil proceeding. When looking at the two codes, one would wish to address his or her mind to the standard of proof and the reason why we have those two sets of laws. If you were to look at the applicability of Order 19, Rule 2, the standard applicable is that of balance of probability. And therefore the judge or the magistrate has the liberty of placing the issues under a weighing scale and juggle the balls. In this proceedings, Your Honor, we are looking at a different standard of proof beyond reasonable doubt. And that's why the parliament deliberately created those two different codes. As I cede the floor, you'll note that this application has not been initiated under the Civil Procedure Code. And there are no rules, again, providing the manner in which an application such as this one ought to be commenced. At least I have not seen any rule emanating from Parliament. This has been as a result of judicial craft, or the DPP's craft, or matters of practice. That is why, therefore, Your Honor, looking at the gravity of the issues and the rights that will be compromised in the absence of cross-examination, the court will be invited to disregard the rules under Rule 19, Order 19, Rule 2, and look at the right that is about to be curtailed. Having been served 5 minutes before you took your seat, then the DPP proposes that we ought to move you with a formal application or a notice of intention to cross-examine, which has not been provided for by the rules or the code, would only be one who is not candid with the truth. We urge you to grant that application. It's the only way the veracity of the affidavit herein can be put to test. The deponent of this affidavit cannot just come and make allegations and then allege that a right to cross-examination does not exist. That right does exist in accordance to Article 50, the right to a fair trial. And suffice to note that Article 50 is one of the non-derogable rights. Therefore, it cannot be waived at the whims, wishes, and aspiration of the ODPP. Others, Your Honor, to say that this is a question of mere discretion would be to miss the point. I yield the floor.